Any mention?
Lordship, Lordship, I beg to mention item number 14.
Yes.
Lordship, we went for this mediation in this matter, but it's not possible to mediate the matter since the other party is not willing to pay the half of the amount also. This is a quashing matter arising out of 138 NI Act.
Yes. Yes.
The mediation, my lord, unfortunately was not successful. Matter may have to be heard, my lord.
So,
It may be fixed after 2 weeks, Lordship.
I'm sure it is submitted by the parties that the parties could not settle the matter amicably. Stop. It is therefore submitted that the matter has to be heard on merits. Stop. As per for list after 2 weeks. Yes.
Obliged, Lordship.
May it please your lordships.
Yes, one by one, yes. Yes, Mr. Gordon.
Lordships, I beg to mention,
Wait. Yes, Mr. Gordon.
Well,
Yes.
item number 19, my lord, of the hearing list.
Yes.
This matter pertains to the POXO matters where the reference is pending before the Chief Justice. Praying for 3 weeks' time. my lord.
Yes,
No objection.
3 weeks.
Obliged.
Yes. Yes.
may it please your lordship. Lordship, I beg to mention item number 11. The respondent number 2 has filed the additional affidavit, but I have received a copy just
Nandu
yesterday
Ramachandran.
evening. So I pray for 2 weeks' time to produce the same.
This is regarding the FIR. Lordship,
Quashing of the
which-
FIR, my lord.
Item number 7.
No, my lord.
11. She mentioned 11. I am appearing in 12, Your Lordship, for the state respondents. We have received the copy of the annexures attached to the FIR on Friday.
Item is. And then she has received response from. She is appearing from.
The
I have
state
received-
respondents in
I'm
item
appearing
number
for the-
11.
Yes. And what you have received now? You have said.
Lordship, I have received the additional affidavit just yesterday evening from Mr. Paske.
What for?
Additional affidavit to bring in
On
record,
record,
ma'am, some documents by the private respondent, my lord, who has lodged a complaint.
Okay. Just say yes. P. Agarwal, learned G. Appearing for the statesman submits that she has received the copy of the additional affidavit filed by the private respondent number. Who private respondent
Number 2.
Two, my lord.
And similar prayers.
And requires some time to go through the same.
Similar prayers made for item number 12 also.
She therefore prays for adjournment of the matter by 2 weeks. Prayer about list after 2 weeks. Then
Number
what
12.
about
Number 12, Your Lordship.
the
Same FIR, my
Same
lord.
matter, Your Lordship.
Okay. So here
Same
also,
FIR was lodged.
but Dr. Agarwal is not here.
No, my
Dr.
lord.
Agarwal is not there. I am there for the state
Okay,
respondents.
so
Your Lordship.
you'll have the same submission.
Same prayer,
Just
Lordship.
the second matter, replace the name of Dr. P. Agarwal and say Madam Yaki. Okay? Yes. Yes.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 15, my lord.
Yes.
My lord, a similar matter is pending before the division bench, my lord.
3 weeks. Yes.
May I please, Your Lordship, I beg to mention item number 18. Lordship, this was referred for mediation, but there was no settlement.
Matter is pending for mediation or mediation is over?
Over, Your Lordship. It was not successful, so I'm appearing on behalf of the state respondent.
So this also could not be. This
It
is
will have to be heard, Your Lordship.
item number 18.
Yes, Your Lordship.
I'm the complainant there, my lord.
Okay. So there also, they say, the parties in the learning council of the parties submit that the mediation between the parties have failed. Mediation between the parties has failed, and therefore the matter requires to be heard on merit. Stop. As prayed for. When shall we list it?
2 weeks, Your Lordship.
As prayed for. List after 2 weeks. Yes.
Obliged.
I beg to mention item number 16, Lordship.
Yes.
Lordship, I'm praying 2 weeks' time, Lordship, in this matter.
No objection. 16 to on the preliminary investigation. Yes.
Similar prayer for item number 20, Lordship.
Here also no objection. 20. Yes.
Obliged, Lordship.
Obliged.
Item number 13, Your Lordship. Actually, this matter went for mediation, and my appointment was only for mediation. So I would like to seek instruction, further instruction, Your Lordship.
The
You were
mediation.
appointed as a mediator there.
No, not mediator, Your Lordship. I
Item
went.
13.
Yes, Your Lordship.
Yes.
The mediation failed actually. So it has come back to the court, my lord. So we'll have to continue hearing.
You are appearing for?
Respondent number 2, Your Lordship.
Who is just number 2?
The DIG DS Armarak.
As a complainant.
Okay.
The complainant. It's complainant.
So, if mediation fails, then it has to be hard on merit then.
Yes, yes, my lord.
After 2 weeks.
Here also, the same thing. Parties on the mediation failed. It's just like previous order. Okay. Yes.
All right.
Yes. This is also another matter has become a never-ending matter. Yes.
Well, I'm praying if this matter could be taken next week, Mala, after the vacations.
Do not know after 1 week whether it can be possible after 1 week. You have to go after 2 weeks if it goes.
A similar pref item 17,
But
Mala.
then who is the other side here?
No objection.
I can't see the other lawyer.
You inform.
I'll inform, Mala. I'll inform. Item 17, Mala.
Then on prayer of the petitioner, list after 2 weeks. Item 17.
17, Mala.
Yes.
No objection, Your Lordship.
This is what?
This is that matter, my lord, where under section, my lord, 223, my lord, as per the new BNS, my lord, the opportunity of hearing is required to be given to the accused person. That was not done, my lord, and someone was issued straight away, so we challenge that order, man.
No objection.
When do we want it?
After 2 weeks,
17 also, 2 weeks. Yes.
obliged.
Please, Your Lordship,
Yes.
I'd like to mention an unlisted matter to the Lordship. There's an urgency.
What is the urgency?
Urgency is because there was a status quo order passed in my favor. In fact, both parties, it's a suit which is there in district council. Now that status quo order was set aside without ex parte, without notice issued to me. So kindly, Your Lordship, today.
The status quo order was set aside.
Yes,
It is
without
appealable order.
notice.
It's appealable order.
Understand, Archie, but the thing is that because of that ex parte order, further not only set aside but further allowed the defendant, I'm the plaintiff, to continue the illegal
But
construction.
then you are challenging it in what? What under what you intend to challenge that order?
The thing is that they had to file a miss civil appeal against the status quo order. That status quo order was not set aside by the same court by the appellate court.
Tomorrow.
Tomorrow, Archie. Pleasure.
Yes.
Very causeless. Item number 1.
Yes, Mr. Marpan, the petition which you have mentioned is a revision or?
Revision, Archie. Revision.
Yes, all right.
Pleasure.
Yes.
May it please Your Lordship, the conducting counsel is on legs in courtroom
What
number
is the
2.
matter about? Cannot say.
Take motion, my lord.
It is an application for remission.
A petitioner is a convict. He is undergoing sentence.
Lordship, yes.
And he is
He has applied for remission, Your Lordship, as per
19
the
years. He is
policy.
incarceration is
instruction,
on.
Your Lordship.
You'll have. We'll issue notice. Send
Lordship, yes.
Hard. Tell you this. Are you there in the case?
My lordship, let the matter may come up at the bottom of the list.
We'll have instruction, Your Lordship. Let notice be issued.
Very surprising, just it's only there's no interim order can be passed in this kind of matter, so notice has to go in any case. Anyway, wait, just let us see.
Mr. Pleasure, Your
You
Lordship.
cannot record name of a person who is not appearing there.
Obliged.
Item number 2.
Yes.
If it may please your lordship, this instant criminal petition, case number 71 of 2025, came up for motion on the 2000.
Clerical, what about the correction?
My lord, this is what I would like to submit before this honorable court. Other than the typographical errors, some other important facts has come before
want
us.
to withdraw the matter?
We would like to withdraw this instant petition with the liberty
Mr.
A. Chakravarti.
Mr. A. Chakravarti, Learned Counsel, will appear for the petitioner.
My lord, I would like to also submit in my humble submission that we would like to withdraw this petition with the liberty to file afresh.
Yes, court has understood what you want to say. We'll just align to it. Yes, Mr. Chakravarti, Learned Counsel, appearing for the petitioner.
And for the state respondent.
On instructions of its that the petitioner does not want to press this application and prays for permission to withdraw the same with the liberty to file afresh. The learned AG appearing for the state has no objection. It's prayer allowed. This petition stands dismissed on withdrawal with liberty as prayed for. Yes.
Pleasure.
Highly obliged, my lord.
Item number 3.
No.
May I please your lordship?
Yes.
My lord, this is the second. On the last occasions, my lord was inquiring. The inquiry that came from the court is that is there no other provisions for challenging in the way of appeal or way of a revision against an order passed
What
by.
is this? What is this case?
My lord, there's an order passed by the special executive magistrate, my lord, requiring me to execute a bond with a, for keeping.
107. What is that?
One,
name?
now is 126, my lord, corresponding to 107
Yes.
CRPC, my lord. And against that, my lord, being aggrieved by the directions, my lord, I've come before my lord, invoking Article 227, and also, my lord, invoking the inherent powers of this court, my lord. Today, my lord, I will not bank on the Article 227, but rather, my lord, I would like to address on the 528 powers, inherent powers of the court, my lord. Of course, my lord, 438, my lord, on the last occasions when we read 438 BNSS, my lord, it gives
Corresponding to 3?
it is revisional power, my lord.
397.
397, my lord. So, my lord, but there is a judgment now in order to just to overcome these obstacles, my lord. There's a judgment, my lord.
Chawla.
Prabhu Chawla and the other one, my lord, which says that, of course, ultimate remedies is not an absolute bar because then we are
See, the question
invoking.
of, you see, saying something as absolute bar.
My lord, my lord.
Okay. And question of, and you see, like allowing it to be entertained on regular basis. There are two different aspects.
My lord.
So that is what is required to be seen. You see,
My,
the thing is that normally if we allow
my lord.
these petitions to
My
be
lord.
entertained under enhanced jurisdiction, then what happens to the regular provision which is there in the code, that is bypassed.
My lord,
That provision becomes redundant.
in my humble submissions, my lord, it won't become a redundant. Why? Because, my lord, from it we'll have to see from case to case basis, my lord. Case in this case, my lord, kindly look at this. In what manner it was passed, my lord. It was passed only on the basis of saying that from the tone and the tenor. It says that, and plus I'm the one who filed an FIR. And I am the one who filed an FIR. I was given a show cause notice. I've submitted my show cause notice, and there is no occasions that where I have I have conducted a breach of peace, my lord. And there is nothing also to record to show, even in the investigation, my lord. In spite of that, just 2 lines, my lord, saying that tone and tenor says that no, he's going to commit a breach of peace.
That is all right. That is something.
Yes.
You see, you are pointing out to improper exercise of jurisdiction.
Yes, my lord.
But then it is not that, you see, like assumption of jurisdiction which was not vested in.
No, jurisdiction was.
If it is something.
Yes.
Like, you see, assumption of jurisdiction by a court.
Yes, my lord.
In a matter.
Yes.
Where it has no power.
Yes.
Definitely 227 will.
My lord. My lord.
Okay, or even 528 come.
Yes, my lord.
But then when it is only improper exercise of jurisdiction, the revisional jurisdiction is there for correction, getting it corrected. Why should we entertain?
No, my lord, there is one word, my lord, which I would like to underline also, my lord, and while I praise my case, my lord, it's an abuse of the process of law. Why do I say that, my lord? There is a procedure for, even if you have to ask somebody to execute a bond, my lord, there's a procedure, my lord. There has to be a report, my lord, and you have to prima facie satisfy yourself that of course there is going to be a breach of peace. It cannot happen only on my show cause, saying that tone and tenor. And besides that, my lord, the show cause that has been filed by the other side have never been showed to me, my lord. And when we have asked for it, they're saying apply a certified copy. I am entitled to get free of course a copy, my lord. Why should I be relegated to applying a certified copy? So therefore, my lord, it's already predetermined in mind that we are going to pass this order binding him, my lord. So this is an abuse of the process of law, my lord.
This court understands, this court
my lord.
Illegality has different
my lord.
Different degrees.
My lord.
Now whatever you say, you see,
my
the court might have done it wrong if you accept your claim.
Yes.
But then it doesn't say that he has assumed a jurisdiction which was not vested in it.
No, jurisdiction part there is no quarrel, my lord.
In such a case, why not go and avail revisional jurisdiction, get it corrected? Revisional jurisdiction is for that only.
My lord, of course it is there, my lord.
Then
of course,
for correcting improper exercise of jurisdiction.
My lord, but my lord, in my humble submissions, my lord, this petition can also be entertained by my lord under the inherent powers, my lord. Of course, if my lord desires me to go for a revision, I will go, but I need to at least.
This is the question of you see, like maintenance and propriety. See, there must be some discipline in.
My lord, my lord. No, because my question, yes, because
it cannot be a random exercise of jurisdiction.
Of course not, my lord, because my contention is, my lord, there is an abuse of the process of law, and the executive magistrate, while passing this order, my lord, did not take enough precautions, my lord, and it did not adhere to what is a procedure prescribed, my lord, and therefore he has violated the principle of natural justice, and above that has culminated into issuing this order, my lord, which is an abuse, which is by way of an abuse of process. That is my power. That is the reason why I have invoked the inherent powers of my lord.
What is this, your lordship? Lordship, in my humble and respectful submission, your lordship.
Yeah.
The order passed by the learned special executive magistrate is revisable, your lordship. It's revisable, and this is revision ought to have been filed before the learned session judge, your lordship, not under inherent power.
My lord, in that matter,
whatever contention had been raised before your lordship, this can be corrected by a revisional court.
That is exactly the view of the court also.
Lordship,
Mr. Yuvin thinks something else.
My lord, exactly in Vinay and other case, exactly this situation has arrived, my lord. And what did the Honorable Supreme Court said?
You see, don't you think there's a matter of discretion?
Of course, my lord. This is
you cannot come
and
claim it as a matter of right.
My lord.
You may show many decisions.
My lord.
You will find, even after Prabhu Chawla also, you will find in 2024, there are decisions 2024 justice.
My lord.
Wherein Supreme Court refused
to entertain. My
Say
lord.
no, when the provision is available.
My lord. My lord, of course, that is.
See, this is a matter of discretion, actually.
My lord, of course, it is.
If we feel that because of certain limitations,
yes,
you are debarred from, preferring the regular revision, definitely you can entertain.
My lord.
But then, as of now, you do not have any obstacle in exercising.
My lord. My lord, in view of that matter, then, my lord, may I withdraw with a liberty to approach the appropriate forum, my lord.
That will be better.
My lord, my lord. I would like to withdraw
But then
with a
you have to
liberty.
satisfy. You see, revision. You have seen that 397 or what is that? You said like new as per the new BNSS. What is that corresponding?
My lord, that is 438, my lord. Yes.
Now, see 438 is see as per the explanation
438 is.
of subsection 1, I think. The executive magistrates all are subordinate to session judge.
Yes. Oh yes.
Isn't it?
Lordship, yes.
So, in such a case, all are
Illegality or irregularity can be questioned, Your
Definitely,
Lordship,
definitely.
before the learned session judge.
That is better.
Admittedly, Your Lordship, it is an order passed by the executive magistrate.
Yes, Mr. Yuvan, learned counsel appearing for the petitioner after arguing for some times. Praise for permission to withdraw this petition with your liberty to approach the appropriate forum.
My lord.
Stop. There has not been opposed by learned AG appearing for the tribunal. Prayer alert. This criminal petition stand dismissed on withdrawal with liberty. Yes, prayed for. It is made clear this court has not gone into the merits of the matters, and it should be open. Short. Let's not cancel it. Okay.
My lord.
All right.
Item number 4.
Yes, Your Lordship.
Yes.
Fine. Lordship, this is a matter where, Lordship, the petitioner, who was the complainant before the Ministerial Court, had filed a 107-145, a non-FIR, Lordship, with regard to certain dispute with his neighbor. Thereafter, Lordship, that application was pending for a good amount of 2 to 3 years without any progress. In the meantime, suit was filed, demarcation was done again, so on and so forth.
Any proceeding was drawn under 107,
It
155.
was not properly drawn up, Lordship. Directly they
What
went
is
for.
It was drawn, Your Lordship.
properly drawn or improperly drawn? What is meant by that?
What has happened is, by one order, 107 was disposed of on an execution of bond, 145 was kept pending.
107 can remain valid for 1 year.
No,
So that is gone.
That
That
is
chapter
gone.
is over.
That is gone.
Okay, then
Now,
145?
145 was pending for a long time. Both the parties filed their respective.
No order was passed there.
No such order was.
Any proceeding was drawn.
Lordship, the record does not say whether any formal drawing up was made or not. Now, in any event, what had happened here, Lordship, is that the matter was left pending for a long amount of time. And in between, because of subsequent developments, Lordship, the complainant, who is the petitioner, wanted to withdraw those 145 proceedings. An application was made for withdrawal of that proceeding, withdrawal simpliciter. That application was also not taken up for a long period of time.
Can it be withdrawn? 145 proceeding once it is drawn up.
In my humble submission, it can be, Lordship, by the complainant.
Is there provision which allows it?
Lordship,
These are preventive
Lordship, yes. Now,
measures, isn't it?
yes,
Now, is it not that the law and order becomes a concern of the state?
absolutely. While Lordship had the 145 mm humble submission is limited to the issue of breach of peace and all that.
This is subject matter which is the concern of the state.
But here what has happened is, while not allowing me to withdraw that proceeding, they have gone and adjudicated the matter and given a finding on the possession of the land, Lordship. And that is affecting my civil rights.
That is given a, see, 145 is with regard to possession only.
Lordship is.
If the executive court gives a finding with regard to your title or ownership, then it is illegal.
Yeah,
But
because
then declaring possession in favor of somebody, that is the work which should be done in 145 proceeding.
but that area of dispute is in dispute before the civil court, Lordship. And now this.
That is okay. That is a different thing. So if civil court pass any order, that will supersede the order passed by 145. That is what the law is.
Also, if there, because what is happening now is that there is a finding by the executive magistrate that this is the thing has been
And is in
settled.
possession of such and such.
Lordship, yes. And they have also given a further finding that both parties have settled. Now that finding is creating a problem in the civil proceeding, Lordship, because the
Settlement
defendants.
is only with regard to possession. Nothing can be.
Because the way, that is what is happening, Lordship. Our main grievance
See,
is that.
it can be in whatever way, but then it cannot be meant to imply in a situation which, by going beyond the jurisdiction, which the court.
Lordship, yes.
This 1045, the executive court's jurisdiction is confined to the possession part only. Possession and breach of peace.
Lordship, yes. Now,
Okay,
why
nothing beyond
the
that.
petitioners aggrieved with this proceedings, Lordship, is that there are two contradictory survey reports. At the time of the 145 proceedings, there were two survey reports. One came in favor of the petitioner,
Survey with regard to what?
the disputed land.
With regard to the land or with regard to the possession of the land?
The possession of the land, I'm sorry. The possession, with regard to the possession of the disputed land.
145 contemplates the provision to conduct a survey.
Lordship, no. Some applications, well, they went for a survey. One survey came in my favor. One survey said that both parties have settled. So my only grievance was that, rightly, wrongly, as on date, Lordship, even my learned friend for the other side, the opposite parties, they would agree that as on date there is no such breach of peace insofar as the parties are
So
concerned.
what is your prayer now?
My only prayer is, Lordship, that the observations made that the demarcation has been done and the both parties have amicably settled. That, Lordship, should not be. That should be interfered with, Lordship, because there was no such
That
settlement.
cannot be a ground for the civil court to go with this. What is the problem in that?
Because they are relying on this very inquiry report in the WS and saying that, see, both parties have settled.
They may rely. They may rely, but then it doesn't mean the trial court should accept it.
Lordship, I
You see,
appreciate.
the fact remains, rightly or wrongly, 145 proceeding, 145 proceeding, such kind of order is passed.
Lordship.
So they are bringing it in their WS. What is the problem in it? What is the wrong in it? Now the acceptance of it, that is where matters.
Lordship, yes.
Nowhere else.
Because that only that observation is creating a difficulty. Lordship. Otherwise, it's a very short issue.
State has no role, Mr. Kharmi.
Matter was sent for, if I may just...
Yes, Mr. Paske.
Yes, Your Lordship. Your Lordship, my learned friend, he wanted to withdraw the proceedings once the proceedings were actually drawn.
Yes.
The proceedings were drawn, thereafter he had filed an application for withdrawal. My Lordship, I would like to take you to Annexure 13 at page 70. The typed copy is at page 71.
Has it come up for final disposal today, Mr.?
It was sent for mediation and thereafter it has come today, Lordship.
This is in the hearing list. Is it in the hearing list?
It's for orders, Your Lordship, not in the hearing.
It's okay. So if you have a, if you do not have consensus between you to go for a settlement, then we have to hear it on merit.
Lordship, yes, because in the mediation also, the opposite parties and both the parties appeared.
Why you have not settled then?
Lord, because one reason is state was not there. And the second reason was that there
State
was
has
some...
nothing to do in 140.
Lordship, yes, but it was their order.
Mr. Kharmi is not at all bothered about it.
Lordship, yes, what had happened fairly, both the parties in the mediation had said that, okay, we don't really have any objection because now they are doing their, other parties constructing their building, we are contemplating to file a suit or whatever. But the problem is they said that since state is not here, we cannot say, we cannot give a consent, let the court decide. That is the...
See, any finding recorded, any order passed in 145 will have no bearing in the civil case. That is what the law is. It is right from 1985, I think, Ramswamy Puri. Yes.
If that small observation can be made, Lordship, that it will not affect the civil rights amongst the parties, then I don't have any, Lordship.
No, Your Lordship, I have objection.
No, why you have objection, Mr. Paske? That is the law.
Your Lordship, here actually a survey was conducted, Your Lordship, on 5 December 2020.
Survey, you prove it in your thing, in your civil case. You go, you exhibit that survey, you prove it in your civil suit. Even if we say that this observation made by the executive court shall not have bearing, it would not mean that you will be excluded, see, you will be barred from proving it before there is a civil suit. You prove your survey report.
Yeah, what was the survey? Your Lordship may kindly go through the order.
Why should you go? Why should you go to the survey? Why should you see? We are not at all concerned about that. We have a limited jurisdiction, Mr. Paske, revisional jurisdiction.
Yes, Your Lordship.
We will not see the merit and demerits of the order. So far as the fact is concerned.
But it's the order that they have challenged to quash and set aside, Your Lordship.
That is all right.
So the order has to be looked upon.
Definitely, we'll see. We are looking at the order. You're looking at the order. What do you want to point out at page 71?
Your Lordship, here the joint survey was conducted. It's the second para, Your Lordship. It's bold.
Yes.
Type copy, Your Lordship. The joint survey was conducted by Mondols, Kanongos.
No, you are reading which order?
This page 71, second paragraph, Lordship.
71.
Second paragraph.
Also seen. It starts with also seen.
Yes.
Okay. Yes. Also seen.
The bold part, Lordship.
Okay.
Here the survey was conducted by the all staff of GHADC. Then the survey was done in the presence of a MCS, Executive Magistrate, and the Revenue Branch of the Office of the Deputy Commissioner, Your Lordship, West Gadwis, and the staff of Urban Affairs, Muda.
Yes. So?
Your Lordship, thereafter it's seen, also seen and perused the joint survey report dated 9 January 2023, which has not been annexed by the petitioner.
Doesn't matter. We are not at all deciding all those aspects, Mr. Paske. What we have to do with this? This court is not going to give any finding on the merits and demerits of the claim and counterclaim of the parties. What is the question?
Your Lordship, there is nothing that is affecting the petitioner as well. The joint survey was conducted by Mondos and so both parties present on the site,
It's
and
okay.
during
They you
survey
open.
we did not find any encroachment.
See, you open. You prove it before civil court. We prove that before civil court.
Your Lordship, that is a matter of trial actually. Yes. Whether there is any encroachment, whether I get that much of land, that is a matter of trial. I only seek that no observations be made that affects the rights of either parties, because it does not say that either parties have not encroached upon each other's lands. That's the
What is the order here? What does it say?
order. It says neither of the parties have encroached upon each other's lands. So
Where is that? Where
their
is that?
lands
Where is
stand
that?
as it is.
In the bolded part
It
only.
is both parties.
So, see,
Both parties.
what is the observation of the court?
The observation is the next page that the matter has been amicably resolved.
Amicably settled.
So
Next page, Your Lordship. It is
Settlements what?
clear from the joint survey
Solved,
report that
they
the
say.
matter
So
issue
that
has
means
already
that-
been amicably solved.
That result in closure of the proceeding.
Lordship, yes.
So then it's okay. What withdrawal has to do here? Withdrawal has nothing.
Only this bolded part, they say it has been settled on the basis of this survey report, Lordship, where there was no encroachment found. That is not correct, Lordship. That is also sub judice before the civil. So only
See, we do not know. This finding cannot have any bearing so far as the civil court is concerned.
Lordship, that is the only.
The civil court. So that is what. So
I'm
there
just
is
praying for an observation
there
in
is a
that
question
line,
of law. Court doesn't have to make any observation.
Lordship. Because they are heavily relying on.
If you just see,
The court did not decide anything also on
Very
the
viable.
ownership.
Anyway, just see, you just say the matter was sent for mediation. Stop. The learned counsel agreeing with the parties that no settlement could be arrived at between the parties. And hence a hearing. Hence a hearing on merit is necessary. Stop. Paragraph. Respect with the parties. List is matter. When shall we distribute, Mr. Pasque?
2 weeks, Your Lordship. 2 weeks.
Respect with the parties. List after 2 weeks for hearing.
Item number 6.
Deeply obliged, Your Lordship.
Yes.
So this is on the last statement, the respondents had sought time to seek instructions in this matter.
My lord, we will be filing a miscase to the matter to bring and record, my lord, what has happened. And then, my lord, the order which is, my lord, indirectly stayed passing of the
What is the
judgment.
subject matter involved here in
This
this
is
case?
no, my lord. This is an arbitration matter, my lord. Arbitration
And
matter.
what is the dispute here?
The dispute is a single arbitrator, my lord, sole arbitrator.
Appointment of arbitrator.
Yes, my lord. So that is before this honorable court, my lord. Now, my lord has passed an order whereby, my lord, my lord has directed that if the final order is not yet passed, my lord, it should not be passed till the matter is decided here, my lord. So, my lord, we will file a miscase. That is the instruction that I have received, my lord, to vacate that order and also to proceed the matter, my lord.
Okay, that is okay. You are at liberty to do it.
Yes, I will be filing it
So
today,
far
my
as the
lord.
revision matter is concerned, is there a separate miscase where this interim order was passed?
Yes, my lord.
Yes, so we'll say that in this case you will file your objection.
Yes, my lord.
Isn't it?
My lord.
Because this interim order is still the returnable, isn't it?
Yes, my lord.
This is
Liberty was granted because the order was ex parte, my lord.
yes.
So liberty was granted for filing an application
Okay.
for modification, alteration, vacation
That
of the
you can do
order.
it once
My
that
lord,
liberty
we
is
are filing it today, my lord.
Okay. Mr. Day Learned Counsel, just write in Miskis 17 of this thing. Mr. Day Learned Counsel appearing for the respondencies that then application that we file a separate application, isn't it?
Yes, my lord, we will be filing.
It has to come in the form of a separate thing, or you can do it in the form of objection also here. Also.
If that liberty is granted, my lord, we will file it, my lord.
Oh, this is filing appropriate application. That means you can file an objection also. You do not have to file a separate miscase.
We'll do that, my lord.
You file an objection instead of say like multiplying the number of cases.
My lord.
Because if you file an application for separate case for vacating the stay, that order will have a bearing there, isn't it?
Yes,
So that is what.
We'll do
So you
that.
can file this next. So you will say that you will be filing an objection.
My lord.
Mr. Day, Learned Counsel, appearing for the respondent submits that.
Then, my lord, since I will be filing an objection, I will pray for 1 week time. Because today it will not be possible, my lord.
Learned Counsel appearing for the respondent submits that an objection against the interim order, against the interim prayer made against the interim prayer will be filed on behalf of the respondent. What you said, Mr. Dear Learned Counsel, appearing with the respondent submits that an objection on behalf of the said respondent will be filed against the interim prayer made by the applicant in this application, and also seeking stay of vacation of interim order dated 24/9/2025. Stop. He prays that he for granted some time for doing so. Prayer allowed. List after
1 week, my lord.
1 week be possible. List after 1 week. Okay, list after
We'll
1 week.
file it, my lord,
Okay,
within 1
list,
week.
list after 1 week. Stop. The interim order passed earlier shall continue till the next date.
Hello.
What about the main case?
Main case has to be heard, my lord. Revision, my lord.
Just list along with miss case number so and so. Miss case number 17. Yes. Is that all right, Mr. Pandey?
Yes, my lord.
Yes.
Obliged.
Hearing item number 8.
Yes.
Lordship, Mr. Chanda is on leg on court number 1. Kindly pass over for some time.
This also after some times. Then what will have? How many matters we can have? Just call after some times. What else? Just call it.
Second call, item number 1.
Oh. Yes.
Wait, please, Your Lordship. Your Lordship.
But that is remission matter.
Yes, my
Yes, we wanted to issue notice, but then your junior was not confident. That is the only thing we can do.
Yes, my lord.
We'll issue notice then.
Yes, my lord.
Yes. At MS message, Lord Counsel for the petitioner, issue notice. Letter delivered in 3 weeks. MSR only, landed GA, APS for all the respondents.
My lord, yes, all the respondents.
All the respondent and hence no formal notice is called for. The landed GA shall obtain necessary instruction before the next date. List after 3 weeks. This one have remission. Why you are not doing if the person is in detention for 19 years?
My lord, I believe because when the last matter was disposed of, we have seen the record. There were a number of convicts who were given remission. So I do not know, my lord. Sometimes what happened, there was some communication.
Instruct your official property.
My lord, yes.
If she is entitled, why should you?
Because sometimes, my lord, they are not able to produce some reliable person to come forward, my lord. So that's why they are not even released. So we'll examine this case also if that is so, my lord.
Highly obliged, my lord.
Call.
Item number 9.
What is that 9? This is second call or is it first call? First. Huh? There are 2 matters. Yes. Item 9 is whose matter?
Lordship, Mr. Chanda.
Mr. Gautam's matter is item 8. Nobody is there. None appears. Ms. Sogra is present for the respondent. List after 2 weeks. Yes. This one. Yes, this is the only matter remaining now. Yes.
Yes.
Well, I'm praying for bail today, my lords. I've served more than almost 4 years out of the...
Why matter is not ready for hearing?
The matter, well, they're supposed to file the reply, my lord. I've already filed my written arguments.
We were supposed to give...